Welcome back, everyone. This is Cassidy O'Connell. We've got a new update on all of the latest filings, and there are quite a few since our last update. But before we get into today's episode, there's one part I'm just bursting about, and I want to talk about that first. Because there's an overlap in this in my usual stories about everything Murdaugh related, and that's about jurisdiction. In reading the New York Times motion to dismiss, I noticed that's something they talked an awful lot about, just demanding that this falls under New York law. And because they put so much stress on it, I felt like this was both their strength and their weakness. Naturally, they won it in New York. They've been in New York since the 1800s. They're one of the longest, most powerful companies in New York City. Naturally, they've paved the way and molded a lot of New York law built on the lawsuits that they've been both plaintiff and defendant in. So of course, they take comfort in the great wall they've built around themselves to protect them from libel and defamation suits. But it was that continuous demand, it's New York state law, it's New York state law, that made me think maybe it's not New York state law, but they're thinking if they say it enough that it will be. And this case is being played out in federal court. So what does the federal court follow when it comes to deciding their cases? Well, in a case like this, where we have diversity, which is plaintiffs and defendants from different states, that's one of the main reasons that landed this case in federal court to begin with. So when you have plaintiffs and defendants from different states, it comes to a question of whose law gets followed when it's in federal court. Now, normally this is an easy answer. There are things like the Erie Doctrine and the Klaxon Doctrine that pretty much cemented to whatever state the federal court is being held in, which would mean New York Times is right. It's a New York case, it's New York law. But when you're talking about a tort, a specific type of civil lawsuit, and libel and defamation and slander, they are all torts. They are an exception to these doctrines. Why? Because of something called choice of law. That means deciding which state's law comes into play. Now, in New York, choice of law for torts is where the wrong took place. And so it still sounds like it's New York, because it was the New York Times that wrote the article, and obviously they wrote it in New York. But when you're talking about libel, defamation, slander, that's not what the courts have ruled. We just covered this in two separate cases. One of them was a state court in South Carolina that relied on a Pennsylvania Supreme Court ruling, and the other was a federal court in South Carolina. Now, the federal case is one that I just reported on a couple of weeks ago with Buster Murdaugh. This is also a defamation case, and it's also a diversity case. His claim of defamation is against Netflix, Warner Brothers, Blackfin, and a few other production companies for having allegedly accused him of the murder of Stephen Smith in 2015. He is a resident of Hampton County in South Carolina. That's where he filed his lawsuit and where he wanted it to remain. It had been removed to federal court due to the diversity and the amount of damages being over $75,000. There'd been quite a long fight about jurisdiction, and it was finally just determined last month that the case would be divided, that Netflix and a local reporter who appeared on the Netflix documentary would be removed back to state court in his home county because they decided that that's where the defamation occurred, since that's where his community is, and that's where it was most important to reinstate his reputation. The rest of the defendants remain in federal court now. Now, Buster, like Justin, has been considered a public figure due to the infamy of his father's conviction of killing his mother and brother and the allegations against his brother of having caused the boat crash that killed Mallory Beach. The news spread across the entire world. It was in things like People magazine. It was on CNN. There were at least 13 books written about it. There are at least 5 documentaries. There's a Lifetime series and a Hulu series in production now. So even though he is a public figure, just like Justin Baldoni, where he resides is where people actually know him and see him going about his daily activities. So that's what the courts decided. The first case, the Austin Stanley versus Will Folks case, has always been in state court. Now, for my regular crew, this case is well known, Austin Stanley being represented by one of our favorites, Mark the Tiger Tinsley. But those of you who've joined since the Justin Baldoni Blake Lively case may not have heard of him. He was one of the key witnesses in the Alex Murdaugh trial.
damages, do you typically get this level of financial discovery of defendants?
I think so. I think the judge ultimately agreed to give it to me.
He agreed to give it to you?
Sure.
But I thought the hearing didn't happen.
Well, you thought wrong. There's a lot of papers, so maybe you got confused.
He granted this motion?
I think so. You want to see the order?
Yeah.
It's the record, October 7th, 2021.
As he was the one pursuing the boat crash that Paul Murdaugh was in, where Mallory Beach was tragically killed. He represents Mallory Beach's family on a couple of different lawsuits. And some exciting news on that, many of you know that there is a Hulu series being made about the Alex Murdaugh case, and it is based on Mandy Matney and Liz Farrell's famous podcast. That is in production and filming now, by the way, and Mr. Tinsley's character is being included in that series, so we will get to see him represented there. But the defendant, Will Folks and Fitz News, are in a different county, and we're trying to get the case moved to their county. But because of the same precedents in earlier cases, like these we're going to talk about today, it was decided that jurisdiction is in Austin Stanley's hometown, which is where the worst of the damage was, since that's where people actually know him, and since that's where he lives today, and that's the people he would be amongst. And so we're going to actually read from this document today, because it deals with the same thing. They went by the same standards. When you're talking about libel and defamation, the place where the harm took place, it's quite different than other kinds of harm. And especially because this article didn't just come in the New York Times newspaper. The New York Times is digitized. It goes out everywhere. They also produced a video about the article that was out on digital, and it goes all across the world. Before, things like libel were just distributed amongst the local subscribers. But now new decisions are having to be made because things don't work that way anymore. Everything is online. So it is available not just throughout your state, throughout your country, but worldwide. And this article is global news. So new rulings, new decisions have had to be made to adjudicate digital news, like this. So how do you rule jurisdiction in cases where these things take place worldwide? So the Supreme Court has held that the gravamen, or the most important part of a defamation claim, is the injury of a plaintiff's reputation, which occurs by publishing defamatory material to someone other than the plaintiff. So that's the publication. It has to be received by a third person. So there's no cause of action until there is publication of the defamatory matter. Now, we have a case that was fought in the Supreme Court of Pennsylvania, Gaetano versus Sharon Herlad Company. Now, what they decided in this case, say the person who's been defamed is in Scranton, but the article is published and circulated in New York City. It states that if no one in New York City knows this person from Scranton, that if there is such recognition of identity but no realization that the article is defamatory, then there is no publication in New York City. But if a few copies of this newspaper published in New York are sent to Scranton and read by the Scrantonians' neighbors or associates who recognize the reference to him and reasonably believe that it is defamatory, then the newspaper has libeled him in Scranton and not in New York City, the place where the newspaper is printed and primarily circulated. So basically, where you are from, where you are known, is where the defamation takes place. In a 2021 case, Lowry versus McBee, that was in the District Court of Appeals in Florida, they held that a Facebook post cannot be libelous until it is published and accessed, rejecting the defendant's claim that what mattered is where the statement originated. In so holding, the court said, a tort claim accrues for venue purposes where the last event necessary to make the defendant liable for the tort took place, or where the harmful effect of the defendant's acts first took effect. Stated another way, a tort accrues where the plaintiff first suffers injury. Here, there was no injury to plaintiff until the allegedly defamatory Facebook post was published and accessed. And a third case they relied on for this decision was also in 2021, Fox versus Smith. This was the Supreme Court of Pennsylvania again, and it was specifically examining the issue of venue for defamation claims. This one from internet publications. So as I said, they were trying to determine whether it should be decided by the same standards as traditional newspaper publications. What they determined is that a defendant's act of publication occurs where a statement is read by a third party and is understood as being defamatory. The court elaborated that the most important function of an action for defamation is to give the innocent and injured plaintiff a public vindication of his good name, primarily for the purpose of restoring his unjustly tarnished reputation. Furthermore, the Fox Court held that although a cause of action for defamation for statements made on the Internet can arise only where the publication of defamatory statement occurs, that acts of publication occur where a third-party recipient receives and understands the statement as being defamatory. And they concluded that where it is the most defamatory, where one's reputation is the most at stake in their home community, and therefore the defendant's motion in this case to transfer venue was denied by the court. So, what does that mean? Your reputation is where you live. That's where you're surrounded by people who know you. For Justin, when he's going to go out and go shopping, that's where he's the most recognized. That's where he will find the most discomfort. That's where he would be seen the most. That's where he would receive the backlash from his defamation, from his own community. That is the particular place of the event. Therefore, choice of law for torts would dictate that the proper venue for his suit against the New York Times would be California. But this is in a federal court in New York. So what does that mean? That the New York Times is wrong about choice of law. No matter how many pages they typed up in this motion to dismiss, proclaiming that the court must follow New York state law for this, New York choice of law states that for torts, it's the place of the wrong, which would be Justin's community, and that the proper state law to use for this case would therefore be California state law. And this would further help Justin's case because, for one, there have been so many pro-New York Times cases in New York, but also, one of the causes of action brought against the New York Times is the false light. This is a recognized tort in California, but it is not in New York. So this could have a big difference in the outcome of this particular lawsuit. So let's get into the rest of this episode. This is Legal Updates with Cassidy. Not so fast, New York Times. This just might fall under California law. Welcome. And now back to the rest of the update. We left off on document 97, which was still in that battle over the protective order. And we have 20 documents in total to cover. Most of them are ongoing things, with the exception of a couple of documents from the New York Times, as mentioned at the beginning. So 98 is a continuation about this proposed protection order. This has been ongoing. Now they say they have 3 discrete or separate and distinct points that they say Wayfair never mentioned previously. Now remember, this fight is about, in addition to the regular protocols put in place to keep information that might be sensitive or protected private, Team Blake is seeking an additional step called Attorney's Eyes Only, that they refer to as AEO. Wayfair has said, we don't need this, we already have protocols in place, and Team Blake is still fighting for it. So what Team Blake is suggesting as their first point is that these rules don't protect third parties, and there are a lot of third parties here. We know that this could mean fellow actors from the set, it could mean Taylor Swift. We don't know yet who might be testifying on Blake's behalf. So far, it doesn't look like many have stepped up, but we just don't know that. So this extra bit of caution makes me think they're really trying to keep any celebrity witnesses they have especially safe. He says this is necessary to avoid serious injury that will occur and already has occurred in the absence of providing sufficient protections. Now, I don't think anyone has suffered serious injury. There are claims that certain people who I suspect might have been the personal trainer supposedly was threatened that their whole family would be assaulted and some such nonsense. Now, that's not okay. And I said so in the last episode. But the thing is, anyone who's going to come forward and testify on Blake's behalf, it's going to be public. Whatever they say will be public. Now, this is a federal trial, so it probably will not be televised, since most federal courts do not allow filming, but there will be media in there present at the trial and reporting on it. There will also be transcripts of the trial that will come out a couple months later. The point is, it will be public. And there are crazy people out there who will DM you with these kinds of ridiculous threats. So as long as the court follows the accepted safety protocols, is this really necessary? And that's the fight they're in, with Wayfarer saying it is not, we have enough, and Team Blake saying we need more. I can't help but wonder if what they're really trying to hide is that they actually don't have much to go on by way of witness testimony or any other evidence, and they're trying to shield that for as long as they can. But I think the most hypocritical statement in the whole document is right there at the end of the second paragraph. Even if it did, requiring third parties to confer with counsel for multiple parties in order to justify withholding highly personal and sensitive materials from the parties, but not their counsel, would place an unfair burden on them. And this is really rich, coming from people who wanted every phone call, every text message, every location ping, in the hopes that just maybe a number will pop up that will prove this invisible smear campaign. Talk about unfair burden. This is nothing compared to that. Now the second point, and they really lay it on thick, claiming that Wayfarer is stating that women who raise sexual harassment claims waive any privacy rights by the stance that they're taking. So they go through the claims again about she attempted to address these concerns and only filed a legal complaint after they launched the retaliatory smear campaign, of which they still have no basis for. And the second point they lay on pretty thick, accusing them of callous disregard and disrespect for a woman advocating for the most basic workplace protections against sexual harassment, and saying that Wayfarer has said women who raise sexual harassment claims waive any privacy rights. But I will concede to one point that Wayfarer did say because she's already outlined all of the details in her complaint, kind of like it's already out there, so what's left to protect? And I do think that was a silly thing to say because that can be, and it has been, mistranslated into saying, as they say here, that a woman who speaks up against sexual harassment has somehow waived any and all privacy interests. I don't think that's what Wayfarer meant by that statement, but it was stated in such a way that it could be mistranslated into this meaning. So they do need to restate that because it could come across as what they're saying here, which would be an awful thing to say. And the third point, they say they open their opposition by bashing Miss Lively and Mr. Reynolds, that's on both sides, for requesting the entry of a protective order to shield from public view documents and information exchanged herein. Then they go on to say that all the other parties are fine with this. It's just Wayfarer who doesn't want this protective order. But again, Wayfarer has never said no protection. They're saying we have a court-mandated protection in place. We don't need to go beyond that. That's all they're saying. And then they get unnecessarily rude, talking about online content creators who frequently parrot the Wayfarer's party line, and saying that one of them is also a client of Bryan Freedman. They seem to be pointing to Perez Hilton because that's the next name. I didn't verify that, but they mentioned Perez Hilton and Candace Owens, who we know has been very outspoken from way back about this case. Now, calling us parrots is so unnecessary. Now, when you say someone is parroting something, it means that they don't have a mind of their own, that they're just repeating something that they have heard, because that's what parrots do. They don't sit there and hold conversations with you. They repeat back or mimic things that they've heard you say. To me, that sounds a lot more like Team Blake, because many of us started on Team Blake's side. We believed her. We tried to support her. But the fact that we changed after seeing evidence shows that we're not simply parrots. The ones who stuck by her after seeing proof that she lied about things, those are the real parrots. We're sitting here digging into the whole story, all the details, proving things not just to ourselves, but to others, based on a deep dive of the evidence. What are Team Blake's people doing? They're not looking to see what Blake's friends are doing, how they're reacting. They're not watching what the cast has said in the past. They're not going through the history of Blake's behavior. None of that. They're not out there trying to convince anyone with any kind of hard evidence. They're repeating the same things. Oh, no one believes a woman. Oh, it's so easy to hate a woman. Oh, you're misogynists. Believe women. I've not seen any of them offer any kind of convincing evidence, any kind of proof. They poke fun at us and repeat things over and over again. That's the parrot side. but he ends it by saying that the mischaracterization embraced by the opposition through this manufactured echo chamber by itself provides ample justification for a protective order that establishes adequate protections for third-party privacy interests. It's not an echo chamber. It's not mischaracterization. It's Blake's own words, it's Ryan's own words, and it's evidence in both sides' complaints. It's the fact that Blake has filed a complaint with the civil department first of all, then an original complaint in her lawsuit, now an amended complaint in the lawsuit, and these have evolved and changed, not in a good way. Justin's evolved and changed by adding more evidence. Blake's changed out of necessity because some of the claims she made on the original ones have been debunked, so she had to take them out or tone them down or change them. But the criticisms that she leveled at Justin so far have not been proven, but all of the criticisms attributed to Blake always come with video proof, her own words. There's no mischaracterization. There's no manufactured echo chamber. Now, most of you probably heard all this because I know if you're like me, you're out there looking around and looking at the latest information. But last week, Blake and Ryan added new counsel, Matthew F. Bruno, and that's found in Document 99. Document 100, we talked about these motions for admission pro hoc vice. Those are for attorneys from out of the district or out of the state. This one is for the New York Times, and it's interesting that it is a California lawyer. And I was thinking that they did this just in case the suit does end up falling under California law, which, as we've seen, one of the causes of action, the false light, is an actual tort in California, but it is not recognized in New York. So differences such as that would be really important if this does happen to fall under California law. They would need someone specialized in California law. In Document 102, this got a lot of conversation on it at the end of last week. I was in Korea, so I didn't get a chance to cover this sooner, but here we have an order from Judge Liman, and I just love when I tell you something of how I think it will go, and the court decides that that's how it's going to happen, and that the why is exactly what I said, and this was one of those cases. This is about the phone subpoena, and I think most of us thought the judge was not going to support these subpoenas. He mentions how the two sides tried to work this out a little bit, and the progress that they made, like removing the location data, reducing it down to just call logs and text logs, but none of the actual messages or anything that fell under the term document. And if you remember, the last fight that Team Blake would not let go of is that they wanted every phone call, every text message log. Wayfarer said this is unnecessary, it's ridiculous, and I said supposedly the smear campaign didn't begin until August of 2024, so how is a subpoena supposed to cover all the way back to 2022 when this alleged smear campaign hadn't even begun yet? And this is exactly what Judge Liman said. He says that she mainly argues that the subpoenas will help to identify the larger network of individuals who perpetuated a negative media campaign against her. But according to her complaint, this negative campaign did not begin until approximately August 2024. It is therefore unclear how communications to and from Wayfarer parties in 2022 and 2023 would reveal individuals who participated in the campaign. And as I also said, even if they trace these numbers back to who the individuals were that they spoke to by phone or texted, that is not evidence of anything. How did they distinguish, of all those numbers that years' worth of phone records would reveal, how did they prove these phone calls or text messages were about a smear campaign? But it just goes way beyond these people's rights to privacy to get their entire call lists and text logs. As he said, on the hope that discovery will turn up information, doesn't justify the broad scope. So he grants the motion to quash, and he does it without prejudice. And if you remember, we talked about the difference between with prejudice and without prejudice. With prejudice is a hard no, don't bring this up again. Without prejudice is a soft no, with the chance to reword the document and file it again. As he says, modified, more narrowly tailored. Now this next bit, I saw a lot of people put a little too much meaning into. The fact that he granted this part, him granting it does not mean that it was okay. It does not mean that he approves of it. The court is limited by rules of what they can rule on and decide. So he explains this ruling by saying that Wayfarer has no proprietary interest in the internal communications of the non-parties. What does that mean? we look at the sentence above, the Wayfarer parties may assert a privacy interest in their own phone records, but they have not provided any basis for asserting an interest in the communications of non-parties. That's the key. So he's saying the attorneys represent the Wayfarer parties. They have what's called a proprietary interest. That's like an ownership interest. It's within their right to protect these assets. They fall under their control. These third parties, because they are not represented by the Wayfarer parties or Wayfarer parties counsel, that's why they have no right to say these are protected. That's all the judge means. He doesn't mean this was too much to ask of the Wayfarer parties, but it's not too much to ask of these third-party people. That's not it at all. He's saying you don't have the right to defend these people. They're not your employees. They're not clients of Wayfarer counsel. So that was mistakenly said, that this was okay for the third parties, and that's not so. And we're going to see this in the next several documents. For example, document 103, immediately after this judge's ruling, counsel for Wayfarer right away files this motion to quash for their employees who are non-parties, but as employees, they fall under this protection. So remember when I read out the subpoenas for who all they were listing, there was Tara Hanks, Malika Toskovic, and Jerry S. Blackman. And I'm sorry if I mispronounced your names, any of you, but this shows us exactly what the judge meant. And we see Wayfarer counsel understood exactly what it meant, and they spread their wings as far as they could over Wayfarer's employees. And 104 is the court responding to that, giving Blake until Tuesday, March 4th to respond to this motion, and also ordering them that no action is to be taken to enforce the subpoenas while this motion is pending. Now, the next three we're going to skip for a moment. This is the New York Times motion to dismiss, their memorandum in support of their motion to dismiss, and also a declaration in support of their motion to dismiss. We're also going to skip 108 and 109 because they are related. 8 is very simple, just a motion to lodge a flash drive with the clerk of the court that contains video that's part of their evidence. And 109 is a motion to stay discovery, also filed by the New York Times. And we'll get into all of that in a moment. We're going to pick up with 110 because it's a continuation of this phone subpoena situation, being attorney stepping up to represent Maxwell Breed, Catherine Case, and Brianna Butler Coslow. There are other third parties who were served with these phone subpoenas. Since Wayfarer couldn't represent them, they needed their own attorneys. And they move immediately to quash those same non-party phone subpoenas. All on the same day, Team Blake, they realized this is the end of the line for this one, so they filed document 113 saying, hey, we withdraw these subpoenas, so this point is now moot. So these attorneys have stepped up to represent these third parties. They've moved to quash. Team Blake knew they weren't going to win this battle, so they simply withdrew. Now remember, it was without prejudice. He told them to tailor the subpoenas better, so we can fully expect that Team Blake will be coming back with new subpoenas for the phone, just something that the court will allow. And then 114 is the court responding to that, ordering that it is moot because the subpoenas have been withdrawn. 115, also simple, and someone had asked in comments about deciding these fights, because this protective order and this phone subpoena both went on kind of long. Now, it looks like the phone subpoena is sort of resolved at this point, except like I said, we can fully expect them to come back with a new subpoena that will need to be addressed. But this protection order is an ongoing battle that they can't seem to come to a decision amongst themselves either, just like the phone subpoenas. So what happens in that case? Just like the phone subpoenas, the judge has to step in. But now this is a little more detailed than the phone subpoenas. That was a pretty easy answer for the judge. It was way beyond the scope of discovery. This one, however, requires a little more than just this back and forth in the motions that have been filed. So, document number 115 is a court order for a video conference to be held, and that's going to be held on March the 6th regarding this protective order. So this will be a hearing where each side who've already filed their motions and put the reasoning behind their motions, but it needs to go beyond that. The judge actually needs to hear them plead their cases, and then either on that day or he may take a couple of days after the hearing to rule on how this will go. But it needs to be heard, in this case, via video conference. So that's going to happen on the 6th. Which is Thursday, so we may have an answer by the end of this week on what's going to happen to those proposed protection orders. Number 116, very simple. This is just a response to 108, asking the court to accept this flash drive with evidence, and they're simply accepting it. And now we're going to get back to this New York Times motion to dismiss. So they, like Leslie Sloan, were gung-ho to get involved in this whole case by starting the whole thing out. Leslie started it by speaking to the Daily Mail when there had been an agreement in place between the PR reps on both sides. For the sake of the movie, do not let this get out. Leslie Sloan couldn't keep her mouth shut, but once she got brought into a lawsuit, now all of a sudden she wants nothing to do with it. Motion to dismiss. The same with the New York Times, who jumped in wholeheartedly to print this article, this very extensive article, without, in my opinion, getting to the bottom and the truth of the story, allowing very little time for Justin Baldoni to respond. As we've all seen, 14 hours, most of it overnight. That's not near enough time. But now they, like Leslie, are, motion to dismiss, get us out of this lawsuit. They no longer want to be as involved as they were in the beginning. Their motion shows up with 6 pages of cited cases to support their side, many of which are their own cases that they fought in the past. It is notoriously hard to sue a newspaper. They hide behind the First Amendment. Not only that, as I said in the beginning, the New York Times has been there since 1851. They have been in these courts so many times in that history. They have been behind the landmark cases, and with the power of a corporation like this, have surely lobbied through the years, whatever needed to be done to get things ruled in their favor. And once these landmark cases get decided, they're just used over and over and over again. I feel like it's time to stop relying on a ruling from 1964. Too much is hidden behind the First Amendment, the right to free speech. It shouldn't mean a free-for-all to say whatever you want to say, no matter how ruinous to people it is, because you're a big-name newspaper. She reported things, and this is my personal feeling on this, she reported things that I wouldn't go near on my little YouTube channel. My YouTube channel is pretty tiny. I'm just under 10,000 subs. And I wouldn't say things like that on here. If I were presented with the story that the New York Times had, there are so many things on that paper that should have been investigated, could have been investigated, and were not. Because it was a flashy story, guaranteed to get views. And anytime you search something newsworthy and the New York Times comes up, you click on it, you don't get to see that article until you subscribe. So them having an exclusive story like this that everybody wants to read, that's a moneymaker. In fact, it was such a moneymaker, they followed it up with the video without, in my opinion, verifying these ruinous things. Now, I've already talked about this with the New York law and California law at the beginning. And the reason I stress that so much is because when I was reading this motion to dismiss, the way they just keep repeating and repeating and repeating, this is New York law, this is New York law, this falls under New York law. I'm like, this is your strength and your weakness. It's your strength because you know New York law is on your side. It's your weakness because you seem to be scared for it not to come under New York law. But the very fact that they said it so many times is what really drew my attention to it and made me start thinking about it. And so, like I said, I feel like it gets abused, the protection that the newspaper has. It has not been successfully sued in over 60 years. Sarah Palin has a current case against it that she had actually lost, but the judge had let it go that he was going to dismiss it. And this got back to the jury before they voted on their verdict, which probably was very influential in their decision. You hear the judge say he would dismiss it. What does that tell you as jurors? But because of that, she gets another chance at a new trial. That's coming up in the spring of this year as well. Now, there's a lot of nastiness in these documents and a lot of hypocrisy. And I'm going to point to the first one in preliminary statement, where they say the Wayfarer parties breathlessly tell their side of an ongoing Hollywood drama. This is such poor taste, considering how the New York Times were salivating over this story of Blake's accusations. I mean, they're here now defending themselves because of what they did. And they're going to say, the Wayfarer parties breathlessly tell their side. Like you breathlessly reported this uncorroborated story. And they retell the story that we've heard so many times from Blake's complaints, from Leslie Sloan, and now again from New York Times, as they told it in their article, accusing Justin of this invisible smear campaign, and saying that it was in response to Blake's claims of sexual harassment and therefore workplace retaliation. In their footnote, they too want Justin's exhibit gone. They all want this gone. Why? They quote these rules as a reason, but the true reason they want it gone is because it refutes all of these accusations. All of them. It refutes the stuff that the New York Times specifically wrote in their article. And now the world knows how badly investigated and poorly written this article actually was, and it should be embarrassing. And they, like Leslie Sloan, pick on some small things, like this impermissible group pleading. And we did talk about this. This case is very complex. Because there are different plaintiffs, there are multiple defendants, and as I stated, this tort claim against New York Times could very well fall under California law, while other things fall under New York law, and none of that's been decided yet. So things get messy, and by admission, when I went through Leslie Sloan's, some of these points will probably need cleaned up in amended complaints in the future, this being one of them. Now, she states something that I don't think is true, but she says that the only defamatory statement that the Wayfarer parties have managed to identify as coming from the Times is that they orchestrated a smear campaign, and that this campaign was in retaliation for Blake complaining about sexual harassment. I don't think that's necessarily true, but they say that this is insufficient because this statement is protected opinion. Now, we reviewed these opinion protections when we talked about Leslie Sloan's motion to dismiss. And I really think in a lot of these cases, they really stretch what an opinion means. Because when you say someone orchestrated a smear campaign, does that sound like an opinion? No, it doesn't. So they say this takes away the actual malice that's required for a defamation claim. Then they say the remaining claims fare no better. For example, this false light claim fails because New York law applies to this action, and New York does not recognize the tort of false light. Again, I think they're wrong. I don't think New York law applies here. I think California law applies here. And New York Times, here's a typo you missed. I believe that's supposed to say breach. So the background again, we're not going to cover this story. We all know this story by heart by now. They say that the article is accompanied by the video that we've already talked about that's now been admitted to the court. And she makes the claim that it was based directly on the CRD complaint. Because remember, this is pre-lawsuit. This is the complaint that Blake filed with the Civil Rights Department. Now, they mentioned Mrs. Tuhey, and I'm not sure if that's how you pronounce her name, and I don't care. Of course, they bring out that she's a Pulitzer Prize-winning journalist, and that she engaged in routine news-gathering practices by contacting Baldoni and the other subjects of her reporting to seek comment. Now, she says that her emails included an extensive list of the allegations cited. She sought comment on them and asked each person to notify her of any inaccuracies or other information that they thought the Times should know. Now look at this sneaky little thing they do. We're talking about 2 different time zones. Look at how they report this time to make it look like it was longer than it actually was. They say they notified Team Justin at 6:46 p.m. and they used Pacific time. You know why? Because that sounds so much better than 9:46 p.m. Eastern time. Then, when it suits them better to flip-flop it for the next day, they say 12 p.m. Eastern time. Why? Because if they kept it in Pacific time, that would be 9 a.m. And that sounds terrible. So had they kept these in the same time zone, it would have accentuated the fact that it was only 14 hours that they were given to respond, most of which were overnight hours. So it was either to spend your whole night replying to this and it's still not enough time, or scrimp what you can of the rest of the night and have it in by 9 a.m. the next morning. Isn't that sneaky? And that's her routine news gathering practices? That's an ambush is what that is. Straight up ambush. And then they make a big deal because they'd given them until noon and then turned around and published it at 10:11. They know that looks bad, so they make a big deal about it, saying no representative of the Wayfarer parties reached out to the Times after Abel's last email at 11:54 p.m. The point is, you told them they had till noon, and you published it almost 2 full hours before that time period. They also say they quoted extensively from the Wayfarer party's response. But when you look at the article, it is not extensively. By her own admission, the denial was 307 words. Do you know how many quoted words she put in the article from these guys that she says she quoted extensively from their response? 58 words. Is that quoting extensively? I don't think so. There, New York Times. That's an opinion. I said I don't think so. That's what an opinion looks like, by the way. The nastiness continues with calling the complaint against them blunderbuss. Literally what it is a gun with a very large bore that fires balls instead of a nice thin streamlined bullet that can hit a target, and so used as an adjective, it means lacking in subtlety and precision. And now I have the right word to call this New York Times article, because it was lacking in subtlety and also precision, in my opinion. Their New York Times, that's an opinion. Now they said that the only thing that they're alleged to have done was to engage in news gathering and publishing. But this news gathering, it was extremely one-sided. It was sloppy, it was rushed, completely lacking, in my opinion, of journalistic integrity. Now, of course, they jump right away into the First Amendment freedoms. We're a newspaper. We can ruin people's lives. It's okay. We're protected. We're journalists. We have Pulitzer Prizes. And we have the New York law to protect us. And here's where they go into all of that about the New York law. They really want this under the New York law that they have had a historical hand in creating. That's a fact. They are the most recognized paper in this country. And these times with newspapers dying, just look at the sheer numbers of profit they still make. And this is in spite of how most Americans feel about whether or not they can trust news being reported to them. And they're still managing to make this amount of money. And so they go on for these pages, emphasizing this New York law, as I said, big part of their motion. And then we get to one of the ways that I feel like the law has been stretched beyond what it meant. They cite the New York Civil Rights Law, Section 74. This protects reporting, and they say that this law protects their fair report privilege. But what does the law actually say? It says a fair and true report, which, first of all, there was nothing fair or true about some of those things that they said, of any judicial proceeding, legislative proceeding, or other official proceeding. To me, that's very clear. A proceeding, by definition, is the process of appearing before a court of law so a decision can be made about an argument or claim. It also means it's something over which a judge presides. And they stretch it to accurate account of a judicial or official what? Document. How did the law get stretched from a proceeding to cover a document? To me, that's not what this original law was, but that's what they have been able to make it become through different court battles where the First Amendment was used and abused to make it even stronger, as in my thumbnail, to make this great wall to protect them. They go on to say that this fair report privilege is absolute, and for that reason, courts in this circuit routinely dismiss claims at the pleading stage upon finding that the privilege applies. They have the system all set up here. Don't even let this claim get past the pleading stage. Shoot it down. But even in this case that they cited, they say the privilege was established to implement the public policy in favor of encouraging publication and dissemination of judicial decisions and proceedings as being in the public interest. Judicial decisions and proceedings. Now remember, this article came out December 21st at 10:11 a.m. Blake's CRD complaint was filed just the day before, December 20th. And they're calling this a proceeding, using words like judicial decisions. This was a private complaint in the Civil Rights Department in California. And here they have this multiple-page article written and put out by 10:11 a.m. the very next day. There is no way that this article was not already underway before Blake filed this claim. We know it takes much longer than that to investigate this kind of claim. They talk about thousands of text messages that they read. When did they have the time, from the time she filed this till the time they posted their article? When did they have time to do all that? They didn't. That means this article was well underway before there was any, not just proceeding or judicial decision, but before there was even a document filed. How does this fall under these laws? This private complaint they call precisely the type of official proceeding at the heart of the fair report privilege. Really? How did you get access to it? Was it public? And now we get to my point about New York. New York courts have broadly construed the meaning of an official proceeding. Yeah, they have. It indisputably applies to legal filings, including complaints. How convenient for you, New York Times. And they say Section 74 protection extends to any pleading made within the course of the proceeding. Was there a proceeding, though? What was the proceeding at that point? It had just been filed in the Civil Rights Department. Because do you know what the Civil Rights Department in the state of California says? There's a complaint process. When someone files a discrimination complaint, CRD evaluates the facts and decides whether to accept the case for investigation. If it accepts the case, CRD independently investigates the facts and the legal issues. This involves reviewing respondents' responses to complaints and other information and evidence that complainants and respondents submit. Among other things, CRD attempts to resolve the dispute in appropriate cases. CRD may also decide to take legal action. What does that tell you? The status of her complaint was on December 21st when the New York Times ran this article. Was it in a proceeding? Does it qualify for what they're claiming it qualifies for? Because from what I'm reading, in the place she filed her complaint, it plainly says they evaluate the facts first and then decide whether or not they're going to accept it for proceedings? No, still not proceedings, for investigation. Then what's next, proceedings? No. If it accepts the case, they independently investigate the facts and the legal issues. Then proceedings? No. Then they get the respondents' responses to the complaints and other information and evidence. Then proceedings? No. They attempt to resolve the dispute in appropriate cases. Then is it proceedings? Maybe. The CRD may also decide to take legal action. Had they? No. What proceeding protects you, New York Times? You have a complaint that had just been filed that you had obviously already been writing your article about before it was filed, not even knowing if the CRD was going to say, hey, this is legitimate. Chances are, had they gotten respondents' responses and evidence, it wouldn't have gone any further. What proceeding, New York Times? And they're still trying to cover this because they give themselves away. They know when they're screwing up. The way they go on and on about New York state law and the way they go on and on about this. Actions and documents involving administrative agencies are official proceedings protected by the Fair Report privilege. An administrative agency investigation into activities within its purview is an official proceeding, and reporting on same qualifies for privilege. What investigation? Was there an investigation yet? No. What investigation, New York Times? And here they are again, trying their best. Absolute privilege applies even in a quasi-judicial hearing, an administrative hearing. Because they know this is not a court of law, but they're saying, well, it's a civil rights department, so it counts too. What hearing, New York Times? And then they go on, and documents related to non-public official proceedings also qualify. What official proceedings, New York Times? And more scrambling. Well, the CRD is the administrative agency responsible for receiving, investigating, and prosecuting complaints alleging unlawful practices in the workplace. So stating a right to sue letter is a prerequisite to judicial action related to employment-related complaints. So it falls squarely within the bounds of the privilege. No, this doesn't prove it. It says it's a prerequisite to judicial action. Your own word, prerequisite, tells you there's no judicial proceeding begun yet. This is a prerequisite to it. It hasn't started. You have to do this first. This isn't like an actual complaint had been filed in a court of law. This is a prerequisite to that. And just like they did with the New York law, but even more so, they take more pages to try to prove to the court that what they did was okay. And I apologize for these trains. They're nonstop. If I keep stopping every time, I'm never going to get this recording finished. I'll try to edit out as much as I can, but if you hear these vibrations, it's a million trains going by. And more covering their actions. They say that the Wayfarer parties contend that the Times colluding with Lively was given her CRD complaint prior to filing. Notice they don't deny this. Because in order for that article to have come out on the 21st, there had to have been. But they say, well, even if that were so, receiving an advance copy of an official document before filing doesn't vitiate the privilege. Doesn't it mean there's no proceeding? She could have changed her mind and not filed it. And then you go ahead and put this, what are you going to do with this article you've been writing? And then they have another New York decision using the very judge in this case, where it says that even if a journalist passed a copy of the complaint by the filing party, that would not prevent the journalist from reporting on the complaint or deprive her fair and accurate report of the benefit of the absolute privilege accorded it by New York law. How is that so? If you interviewed before, not only are you not talking about something that's in a proceeding, you're talking about something that hadn't even been filed yet when you wrote your article. How is that okay? And they go on to say that the Wayfarer parties claim that the Times interviewed Lively before the publication of the article and video similarly does not change the outcome. So they're basically like, well, so what? So what if we talked to her before? So what if we wrote this before? It's okay in New York, even though it's not what New York law supports. Clearly, it's okay. We do it different here. It's plain and simple. When that document has not been filed, by any stretch of the imagination, is it belonging to a judicial proceeding? And we saw, again, from California, CRD itself, it was a long way from a judicial proceeding, even having been filed, because they investigate first. Then they go on to say interviewing a source before publication is not collusion, it's news gathering. This great wall built around them, all these little ways that they're getting away with way sidestepping what the law actually was meant to allow. And then this one just blows my mind. The Wayfarer parties hint that they believe the article and video are not privileged because the Times made little or no attempt to investigate the veracity of Lively's allegations. But listen to this. The argument exhibits a fundamental misunderstanding of the privilege and its purpose. They say the point of the privilege is this, that journalists should be free to accurately inform the public about official proceedings without having to fact-check them. That's an oxymoron. How are you informing the public accurately without fact-checking? How do you make sure it's accurate if you're not fact-checking? This is insane. Under the privilege, journalists are not required to fact-check allegations, only to provide a fair and true report of them. So it doesn't matter if it's lies, they can still consider it fair and true. How does that make sense? If these are in fact what their laws are, something seriously needs to be changed. Because surely the First Amendment was not put in place so that newspapers could say whatever they wanted to say about anyone and get away with it. And they say the Wayfarer parties claim that the article and video should have included the reasons why Nathan was hired to bury Lively. They say once again, plaintiffs exhibit a deep misunderstanding of the privilege. We're privileged. We can do whatever we want, Wayfarer. Because you know why? The long-standing Times policy? The privilege itself imposes no obligation on a publisher to tell both sides of a story. We don't have to. It might ruin the sales of our story. If you hear the other side and find out these accusations are not true, you're going to ruin my story. You're going to ruin my sales. I'm privileged and I can say whatever I want. This is so wrong. And they say they went above and beyond and did reach out to the plaintiffs. For overnight, a few hours before most people go to bed, and an hour or two after most people wake up, and then it was printed by 10 Eastern Time. You know that's 7 Pacific Time? That was above and beyond? Did they hold an interview? No, they sent an email. We're going to accuse you of this horrible thing. Even though you men are married and you have children, we don't want to talk to you. Ew. We're going to send you this little email to cover our butts and give you a few hours to respond, and that's above and beyond. But we've been talking to Blake for months. We've interviewed her. We've looked at all her evidence. That's above and beyond. Aren't we great? But we're protected. And here they use that same stuff that Leslie Sloan used. Oh, it's protected opinion. It's rhetorical hyperbole. Told the whole world. That's rhetorical hyperbole. Saying that Wayfarer conducted a smear campaign is a statement of fact, not opinion, not hyperbole. They say that it lacks any precise meaning. Is smear campaign undefinable? Were they not clear what the smear campaign was in their article? Because I think they were very clear. They were very precise. There's pages of details of what is meant by the smear campaign. How is this hyperbole? How is this lacking precise meaning? They made sure we got the meaning very clear. Then they say again that they haven't proven that the Times published the article with actual malice, start throwing around the New York's anti-SLAPP law again, just like Leslie Sloan did. And they misrepresent the definition of actual malice. They give it as to sufficiently allege that a statement was published with knowledge that it was false or that the publisher entertained serious doubts about whether it was true. That is not the definition. The definition includes, or with reckless disregard of whether it was false or not. Guess which lawsuit that's from? The very one they hide behind. New York Times versus Sullivan. You don't have to know or have serious doubts about the truth of it. You just have to have acted with reckless disregard, giving them the short amount of time you gave them to make a competent denial, choosing to not interview them so that they could provide you with evidence for their side is reckless disregard, in my opinion, that you didn't want to see because you wanted a juicy story, and if you got evidence that this wasn't so, it wouldn't have sold as many copies. There's my opinion. And they repeat this again about the false light claim. They say it fails because this is under New York law, and New York law does not recognize the tort of false light. You're wrong about that. And then they go on to these other smaller ones that they call tag-along claims, promissory fraud, breach of contract, and say that those fail as well. Some of these things may indeed need to be cleaned up in another amended complaint. As I said, that hopefully says, no, this is California law. And so they conclude by accusing the Wayfarer parties, this is so rich, of telling a one-sided tale that has garnered plenty of headlines, and then say that they don't belong in this dispute, even though they told a one-sided tale that garnered plenty of headlines. Respectfully submitted, Catherine Bolger. And the next document is her declaration in support, and she includes 9 exhibits with that. The first one is the New York Times article itself. The second one is that flash drive that was submitted with the video. Exhibit 3 is Blake's CRD complaint. Then we have Exhibit 4, some of these emails. Subject, urgent questions from New York Times. It's very clear that she's already decided whose side that she's on. There's nothing cordial about the way she addresses these people. There's nothing apologetic. She thinks she has found the next Harvey Weinstein story, and she goes in with that attitude. She makes a bullet point style list of the accusations that Blake made, and in very short, curt sentences, tells them she wants a statement from them. But does she really? Jennifer Abel actually replies, "Let's see how that goes." Jennifer Abel answers it is shameful that Blake and her representatives would make such serious and categorically false accusations against Mr. Baldoni, Wayfarer Studios, and its representatives, as yet another desperate attempt to fix her negative reputation, which was garnered from her own remarks and actions during the campaign for the film, interviews and press activities that were observed publicly in real time and unedited, which allowed for the internet to generate their own views and opinions. These claims are completely false, outrageous, and intentionally salacious with an intent to publicly hurt and rehash a narrative in the media. Wayfarer Studios made the decision to proactively hire a crisis manager prior to the marketing campaign of the film to work alongside their own representative, with Jones Works employed by Stephanie Jones, due to the multiple demands and threats made by Miss Lively during production, which included her threatening to not show up to the set, threatening to not promote the film, ultimately leading to its demise during release, if her demands were not met. It was also discovered that Miss Lively enlisted her own representative, Leslie Sloan, with Vision PR, who also represents Mr. Reynolds, to plant negative and completely fabricated and false stories with media, even prior to any marketing had commenced for the film. Which was another reason why Wayfarer Studios made the decision to hire a crisis professional to commence internal scenario planning in the case they needed to address. The representatives of Wayfarer Studios still did nothing proactive nor retaliated, and only responded to incoming media inquiries to ensure balanced and factual reporting and monitored social activity. What is pointedly missing from the cherry-picked correspondence is the evidence that there were no proactive measures taken with media or otherwise, just internal scenario planning and private correspondence to strategize, which is standard operating procedure with public relations professionals. Now, where in this article is any of this statement? It is simply not there. Why? Why wasn't this printed? They took Blake's word, they asked for comment, and they didn't bother to print any of Jennifer Abel's response. There are so many accusations here. that a journalistic mind should have been like, wait, what? She did what? Can you send me documents about this? Can we talk about this? Can you call me? This is a big story. But she deliberately chose not to put any of this in here. But you know what? It backfired. Because this stuff is the real story. And this is what everybody wants to hear. Because there's evidence of all of this. She could have told this story, but she didn't print a word of this. You know what her response is to this? Thank you for your response. Can you kindly clarify who is represented by this statement? Not can you clarify any of these points. Who is represented? Is this statement on behalf of Mr. Baldoni, Jamie Heath, Steve Sorowitz, you, Miss Abel, and Melissa Nathan? Who is CC'd on this message? Please let me know. After all that information Jennifer just gave her, this is all she wanted to know. How is this not reckless disregard of whether it was false or not? She was given the other side of the story, and she recklessly disregarded it. Left it out of her article altogether. She quoted 58 words of Bryan Freedman's statement and none of Jennifer Abel, who is all over Blake's complaint. How is this not reckless disregard for the truth? And Jennifer says yes, and Jed Wallace, and that's the end. No more questions. Got what I needed. And at this point, that article was already written. And then she adds all these exhibits as if there's just so much information here. Basically, it's her same form letter that she sent to each of the people, yet somehow only quoted Bryan Freedman. 109 is called a motion to stay. This is also filed by New York Times, and what this is, and if you're from my Murdaugh group, my Cassidy's crew, you've heard of this motion to stay. Once a motion to dismiss has been filed, you're waiting for the court to respond on whether or not your case will go on or be dismissed. So in the meantime, the New York Times doesn't want to have to provide discovery, because something in that discovery may actually bring more action against them. So they filed a motion to stay, asking the court not to make them have to give any discovery to the plaintiffs until the court decides on whether or not this case will continue. So right away, Team Justin files a response in opposition to this motion to stay, saying that just because a motion to dismiss has been filed, that doesn't mean discovery should routinely be stayed, and that the court should consider multiple factors, including the breadth of discovery sought, the burden of responding to it, and the prejudice that would result to the party opposing the stay. They say the Times has not demonstrated that the discovery sought from it will be voluminous or burdensome, and that they're speculating when they say that this discovery would be far-reaching and expensive and wrought with complications. And I love this little thing he adds. To the extent that the Times is concerned about requests for call logs and other extensive discovery, we note that such overly intrusive discovery was sought by the lively parties, not the Wayfarer parties, referring to these phone subpoenas, and that the court advised the lively parties how to appropriately narrow their discovery requests. They say that the claims being dismissed is unlikely and that the Times would remain a critical percipient witness even if their claims are dismissed. So this discovery is going to have to come anyway, whether they remain a defendant or are witnesses. They also say that the Times has failed to establish that the Wayfarer parties will not be unfairly prejudiced by their request for a stay, and that they cannot predict how the court will decide on this motion to dismiss. They say that the Times has not made a strong showing that the claims are unmeritorious, and that the Wayfarer parties' claim against the Times are asserted under California law. Drive that point home harder. And they say that even if New York law were determined, the court cannot determine the outcome of this because it's for a jury to decide. And so they ask the court to deny this motion for a stay of discovery, or at least at a minimum, document discovery with the Times should proceed, and stay the party's deposition only pending its motion to dismiss. So the Times is getting deposed either way. And then comes the absolute devastating news. An order came through from Judge Liman granting this stay of discovery. Not only that, he says the New York Times motion presents substantial grounds for dismissal, and the New York Times has made a strong showing that its motion to dismiss is likely to succeed on the merits. So here's the judge in the case, letting them know he's leaning towards granting the New York Times this motion to dismiss. And he goes on to speak about the voluminous discovery. And I'm disgusted. Just absolutely disgusted. So that brings us to an end of these 20 new documents filed since our last update. I suspect Bryan Freedman is going to come back swinging very hard against this motion to dismiss, which I will happily cover with you as soon as I can. Till then, this is Cassidy O'Connell. saying stay well and stay tuned.